Hey, how is everybody? Welcome to week 4. We're almost at the halfway point, so if you guys are having any issues, you need to let me know about it. I am on vacation up in the mountains in northern New Mexico, so while you guys are viewing this, I'm like hanging out. So, sorry you won't be able to ask questions tonight, but be sure to email me with any questions and we will get through this the best we can, okay? All right. So far we have covered how we come into the country, and then when we go through inspection, and then we figured out whether we're admitted, paroled, or removed. And then once we're admitted, we figure out, you know, did we come in, what type of visa? Was it a non-immigrant visa or an immigrant visa? And we've been discussing all the non-immigrant visas that individuals get at their consulate in their home country, and they're usually temporary visas. They have a beginning and an end, so we refer to them as the alphabet visas. They come to the U.S., they're admitted, they get their passport stamped, and they get the authorized period of stay on their I-94. Now, tonight we're going to move in, we're going to start talking about legal residency and what is a permanent resident, and then how in immigrant visas and how you become a permanent resident, okay? So we're kind of on course to kind of moving out of from the non-immigrant visas, and kind of we're going to be figuring out how people actually file for immigrant visas, and then eventually how do they actually obtain their lawful permanent resident card. Now, LPR is the acronym for lawful permanent resident. You're going to hear that a lot. A lot of people refer to it as green card. So green card holder and lawful permanent resident is the same thing. I'm going to refer to it as an LPR. So basically, you know, what is an LPR? It's a someone who's been granted legal permanent residency. They have a right to permanently live in the U.S. So they can live and work here in the U.S. They can go to school. Their kids can go to school. They can travel in and out of the country. They do have certain restrictions about as far as how long they can stay out of the United States at one time. They have almost the same rights as a U.S. citizen, but not quite, because there are some restrictions there. And we know that they cannot vote in any government elections, okay? So that's the main thing, all right? Okay, so how do you actually obtain your permanent resident status would be the next question. And there are several ways people can actually become a permanent resident of the United States. And we have them listed here through a family relationship, and we're going to discuss that tonight. We're really going to focus on family. Through employment. So a lot of people actually get their permanent residency through employment. Through asylum, which we're going to be talking about in a couple of weeks. That's basically you have fear to return to your country, fear of persecution if you go back. And we actually have a U.S. lottery where we actually grant permanent residency to those if their country is allowed to enter into the lottery. Legalization and cancellation of removal, where we're talking about some relief from actually deportation and actually removal of deportation proceedings in court. But tonight we're going to focus on the immigrant visas, and we're going to focus how could you actually become a permanent resident through a family relationship. All right, so before we get there, let's talk about the requirements for permanent residency. And there's basically 3 things you got to show. Anyone's got to show, whether it's through employment or any of those categories I just mentioned before, employment or family, that you've got to be able to show that you are eligible for permanent residency. Is first, you've got to establish that you're statutorily eligible for it. Second, you got to show that you meet the quota if you are subject to one of the quota systems under the preference categories, and you've got to show that you are admissible. So what do we mean by these 3 things? First of all, we must know the difference between admissibility and deportability. Admissibility refers to someone who they were probably admitted to the country legally, okay, so they were legally admitted to the U.S., but now they may not be admissible after they've gotten in the U.S. Maybe their status has expired or something something like that, and they need to be removed. And then, of course, we have deportability, refers to persons who, after entry, may be removed. They're in violation of visas or something like that. Okay. Just was checking out these slides. Let's go back to being statutorily eligible just for a minute. When you come into the U.S. and we say statutory eligible, we got to show that sometimes for permanent residency you may need to be follow some rules such as, are you the correct age? Are you statutory eligible because you haven't aged out or something like that? Quotas, we're going to find out when we get into the preference categories. You have to meet a certain quota. A lot of the preference categories have quotas. And then admissible is to show that you haven't done anything that makes you inadmissible. There are several things listed under inadmissibility that maybe you were entered legally, you were admissible. However, one of those things could be a health concern. If you had active tuberculosis, you would be considered inadmissible. So that could, it's not that you're statutory ineligible, it's that you don't meet the admissibility requirement. Okay? All right, so we're going to start with family immigration here. Basically, when we're looking at family immigration, we usually have a petitioner and we have a beneficiary. So in immigration, we will see this not just in family, but we see this in employment as well, that you always have a petitioner. The petitioner is the person who is filing the petition on someone's behalf. So in a family relationship, the petitioner is going to be, if it's by marriage, the U.S. spouse is filing for their foreign-born spouse. Okay, so the petitioner is the person who files a petition. General rule, either it's going to be a United States citizen, which is acronym USC, or lawful permanent resident, an LPR, who's going to apply for an immigrant visa on behalf of the alien. Okay? So with family-based immigration, we know the petitioner is always either going to be a USC or an LPR. We do have some exceptions where actually someone could self-petition for themselves, that they don't need a petitioner. We don't see it very often. Usually that's in the battered spouse category. And then, of course, if you have the petitioner, we have the beneficiary. Who's the beneficiary? The beneficiary is the person on whose behalf the petition is being filed. Okay? So let's go back to our example of a marriage case. In a marriage case, the petitioner is going to be the U.S. citizen or the permanent resident. The beneficiary is going to be the alien who's maybe married to the U.S. citizen or the lawful permanent resident. Okay? So you want to make sure, because you will see these again, you want to make sure that you understand these definitions of petitioner and beneficiary. Okay? So basically, how do you go about getting this permanent residency? And there's two routes to permanent residency. So you can either go through the process at a U.S. consulate abroad, or you can go through the process here in the United States at a USCIS office. Okay? If you're going to go through this process where you're trying to obtain permanent residency through a relative, employer, something like that, at a consulate, it's called consulate processing. Okay? And basically, consulate processing, we know that the beneficiary is outside the U.S. seeking an immigrant visa at the U.S. consulate to come into the U.S. Okay? So consulate processing is never done in the U.S. It's always done at a U.S. consulate. U.S. consulates are located at embassies around the world in certain countries that we have consulates located at. Okay? Now, the one thing about consulate processing is that for someone to actually to become a green card, they can't do it at the U.S. consulate. They have to travel to the U.S. They have to complete inspection before that alien would be considered an LPR. Okay? So let me explain that. All right. So let's say we're going to a U.S. consulate in London. Let's say we have Joe, who is a U.S. citizen. He's applying for his wife, Mary, who is an alien because she's a citizen of the United Kingdom. She wants to come to the U.S. So Joe files his immigrant visa, okay, to get Mary to come to, he files his immigrant visa here in the U.S., he gets his immigrant visa approved, and now Mary is going to go to the U.S. consulate in London to try to come to the U.S. because she's seeking an immigrant visa so she can become an LPR. Now, she cannot become a lawful permanent resident until, even though when she's at the consulate, she gets what's called LPR status. She gets a stamp on her passport saying, you are LPR status. That does not mean that she's actually a permanent resident. She doesn't actually become a permanent resident until she has to travel to the U.S., get off the plane, go through inspection. We talked about that, how everybody goes through inspection. And when she goes through inspection and the immigration officer at CBP sees, oh, I see you have immigrant visa stamped in your passport saying you have an LPR status. Okay, great. It's going to ask her some questions. Boom, that's it. He gives her the stamp that she is now considered a lawful permanent resident of the United States. Okay? So, key thing to remember about consulate processing is this last thing here. You have to actually travel to the U.S. To be considered an LPR. So, what does that mean? Let's say Joe and Mary, let's take them. Mary gets her immigrant visa at the U.S. consulate, but she doesn't want to travel to the U.S. Maybe she's got a sick mother at home, so she stays there. So she was granted this LPR maybe in 2005. Here we are in 2015. Is she a permanent resident? No. She will never be a permanent resident until she gets on that plane or ship or however, comes to the U.S. and goes through that inspection process. Okay? All right, so the second route to permanent residency that we see a lot more of, it's called adjustment of status, okay? And adjustment of statuses are always done here in the U.S. So that's how you can tell the difference between whether something's, how something's being handled. If they say, hey, I'm going through consulate processing, they're trying to get their immigrant visa approved for an LPR status at a consulate. If they're saying, hey, I filed for adjustment of status, then we know that they're here in the United States. They're applying at a local USCIS office to actually obtain their adjustment of status. Now, you notice that it says adjustment of status, and that's because up to this point, everyone is probably here in the U.S. either on a non-immigrant visa where they have a status, a beginning and an end, okay, and they may have gotten an immigrant visa approved, but they're not actually getting out of the status category to become a lawful permanent resident until they go through this process. It's called adjusting status. So you're not changing status, you're adjusting it to become a lawful permanent resident. And so how do you do that? To be able to adjust your status, the form you file is called an I-485 adjustment of status with who? USCIS. How do we know we file with USCIS and not any other agency? Because we're asking for a benefit to adjust to a permanent resident. That would be considered a benefit. That's why we file with USCIS. Okay? Now, when you file your I-45, you got to show two things. You got to show that your eligibility. You got to show that if you're in the U.S., you've been through inspection, okay, and that you've been admitted, and that you are in status. Okay? We do have some exceptions for status that we're going to go through, and then you have to show that you have a visa available. So what do we mean by this visa available? And that's what we're really going to get into covering tonight, is how do we actually know when our visa, our immigrant visa, is available. Okay, so, but before we get there, let's talk about what type of relationships are actually recognized here in the United States, okay? Parents. Do we recognize relationships of parents? So can a U.S. citizen child file for her U.S. citizen parents? Yes, absolutely. We're going to see that when we get to the visa categories. What about kids? Can U.S. Citizen parents or lawful permanent resident parents file for children? Children are considered under 21 and unmarried? Absolutely. Siblings? Again, yes, we can file for them. But here we get into something tricky. Aunts and uncles and grandparents. Can U.S. citizens or permanent residents file immigrant visas on behalf of aunts and uncles and grandparents? The answer is no. So you cannot file an immigrant visa on behalf of a grandparent or an uncle. So that's one thing you want to remember. All right. Here is something very important that you guys are going to need to know. when we're talking about who can actually, we're talking about family relationships, and we're talking about who can actually apply for their family relative to become a lawful permanent resident, okay? And the first thing that we want to know is we want to know who is considered an immediate relative, okay? Very, very important to know who is an immediate relative, all right? Because immediate relatives can always adjust status here in the United States. So the definition of an immediate relative is a spouse of a USC. All right, so that means anyone, husband or wife, anyone that marries a U.S. citizen is considered an immediate relative. So who else is considered an immediate relative? Children of United States citizens who are unmarried and who are under 21 years of age. Remember, we talked before about dependents, and you're not really considered a dependent if you're married and under 21, so that's why it has to be unmarried and under 21 years of age. You are considered a child, and that means you would also be an immediate relative where if your parent was a U.S. citizen, and you were not, or your parent married a U.S. citizen and you are not a U.S. citizen, they could apply for you as well. And then, of course, parents of USCs are considered immediate relatives also. So we're a U.S. citizen and we want to file for our parents and they're not U.S. citizens, we could also file for them right away. Now, this is really important. I know you're wondering, what does this word no quotas mean? When we get into the visa bulletin, which we're going to study tonight, and which I should have mentioned at the beginning of the lecture, but I'm going to send you an announcement on, you need to have the most recent visa bulletin to understand what we're going to talk about in the lecture tonight and to do the assignment. So we want you to have the visa bulletin for May 2015 is what we're going to follow, okay? And so you will see on this visa bulletin how the quotas come into play, okay? All right, and so you see that visas are always available for immediate relatives. So who are immediate relatives? Very important to know. If our petitioner is right here in the middle, we know our petitioner has to be a USC. So who can a USC file for? They can file for their mother and father, who are their parents, and they can file for their kids who are under 21 and unmarried. And that's pretty much it. So you know who immediate relatives are. It kind of goes up the chain, mom and dad. It goes below your kids under 21 and unmarried. All right? Now we're going to get into what we call visa categories, okay? And this is under the visa bulletin. So you guys should have gotten the memo on that you should have the visa bulletin for the class tonight. If you don't have it, you want to stop the recording and go and get it. You can get it at travel.state.gov. Look up the most recent visa bulletin, which should be May 2015, and you want to be I would go ahead and print it out if you can. If not, have it handy on your computer so you can refer to it, okay? Because you're going to need this visa bulletin as we go through some exercises and for your assignment, okay? Now, basically, what the visa bulletin is the visa bulletin is going to show availability of visa numbers and give a definition of preference categories, okay? So, to back up and explain this deal about immigrant visas a little bit. We know that you can come here on a non-immigrant visa and you get your visa at the consulate. A lot of people, once they come to the U.S., and let's say they marry a U.S. citizen or they have a relative back home, like a parent or someone, and they want to file a visa bulletin, visa for them to come and become a green card holder, the first step is you must file what's called an immigrant visa. So you have to file an immigrant visa before you become a lawful permanent resident. It's part of the steps. You can't directly just become a lawful permanent resident. You have to file for an immigrant visa first, okay? And so the visa bulletin is going to show us what visas are available, and it's going to give us definitions of the different preference categories. Because under the preference categories in the visa bulletin, what we're going to see is that all the categories have annual quotas. And once those quota limits are met, then there aren't any other quotas available to anyone that maybe wants to come to the United States in a certain category, okay? So I know this is kind of getting kind of confusing, but once we actually look at the visa bulletin, I think it's going to make a lot more sense, okay, guys? All right, so we're going to look at, first thing we're going to do is you want to go to the actual May visa bulletin, okay? Now, I'm giving you the categories that if you're looking at the actual visa bulletin in front of you, you're going to see a lot of different stuff on there, but you're also going to see that you're going to have different preference categories. Let me find my visa bulletin. So on the first page of the visa bulletin, it talks about the statutory numbers, which is available to you. And then if you go to page 2, you should see at the very top that it says family preference categories, family sponsored preferences. And these are the actual different preference categories. And you will see who is included in first preference. First preference is children over 21 years old, okay, and unmarried of a USC. Because remember, the definition of immediate relative can file for their child who's under 21 and unmarried. So now we see that we have a way to bring children who are over 21 and that are unmarried of U.S. citizens. And it's considered first preference, okay? Second preference, this is interesting. You'll see this preference only refers to LPRs. LPRs are lawful permanent residents of the United States, okay? So what categories are in LPR? We have 2A and we have 2B. So a lawful permanent resident can actually sponsor their spouse, children under 21 years of age and unmarried, and they can also sponsor their children over 21 years age and who are unmarried. Okay, so we know that an LPR's got 2 categories, one for their spouses and kids under 21, unmarried, and one for their kids who are still over 21, but they're still unmarried. Then we see we have third preference. Third preference is basically just for married kids of USCs, okay? Doesn't matter how old they are, but if they're married, this is the category that they would fall into. And then we have the fourth category, which are siblings of a USC. Does everybody see that? All right, so we basically can see how those categories work. Now, if you look below the 4 preferences, right below that, you are going to see a chart. And on the chart, it says all chargeability areas. You see that actual chart in there? I thought that was listed in here, but it's not. You see, it's like a chart. And in the first section of the chart, it says family sponsored, and you have columns. And in those columns, the first one, you've got F1. F1 is considered first preference. And then you see F2A. F2A is considered second preference. And you've got F2B, that's again second preference 2B. You've got F3, which is third preference, and F4, which is fourth preference. And then next to that, you're going to see you've got a column that says all chargeability, and then you've got China, you've got India, Mexico, and the Philippines. And then you will see under each of those columns, you see different dates listed, okay? What these dates mean is basically these dates are actually showing us the preference category that is actually current and available to someone who has filed a visa petition on behalf of someone, okay? All right, so basically what we're going to learn tonight is we are going to learn how to read the actual visa bulletin, okay? All right, so we know our preference categories. Yes, everybody's with me on that, yes? First, second, third, and fourth, we have that. If we go to the next thing, and it's going to tell you this about how do we actually read this visa bulletin, a couple things we need to know, okay? The actual form that you would file for an immigrant visa is an I-130, okay? So let's say we have our U.S. citizen spouse who is now married Joe. He's married Maria. Let's just say Maria is from China, okay? So we have Maria who's living over there in China. And Joe wants to petition for Maria to come to the United States. So that means Joe wants to file an immigrant visa on behalf of Maria so she can become a permanent resident of the U.S. So the first thing we would have to figure out is Maria a immediate relative, or is Maria in a visa preference category? Well, if we look at our definition of immediate relative, a spouse of a U.S. citizen is considered an immediate relative. There's no quota system. There's no wait time. That means that Joe could file an immigrant visa on behalf of Maria, and there would be no problem. Okay? Now, let's say Joe is a permanent resident of the United States, and still Maria's from China, and he wants to bring Maria over here. So still, the form he's going to file is an I-130. You're always going to file an I-130. That's the form that you always file for an immigrant visa for a family member. It never changes. It's always going to be an I-130 is the form. Okay? So for anybody that's on the preference categories, and you see you've got 4 preference categories there, 1 through 4, any individual that falls into one of those categories is going to have to file an I-130, which would be their immigrant visa, to make them eligible to come to the United States. Okay? Now, what we want to know about how, before we can actually read to the visa bulletin, is we have to know exactly what is a priority date. Okay? So the whole purpose of this visa bulletin is it's going to tell us the number of available visas in a preference category, and it's going to tell us what visa bulletins are available to us. And the way we read it is we have to determine the priority date of the visa petition. So what is a priority date? A priority date is the date the filing of the visa petition. And of course, the visa petition is going to be an excuse my drawing here, 130. Okay? So, Joe files his visa petition for Maria, who's from China, on January 1st, 2015. Okay? Write that down. January 1st, 2015 is the date that Joe files his visa petition for Maria. So we know that the priority date is the same as the filing date of the petition. The actual priority date of this petition filed by Joe is going to be January 1st, 2015. So, how do we know if a visa is available to Maria or not for her to come to the United States? Where would we look to see if a priority date is current? We would look at the visa bulletin. Where do we find the visa bulletin? It's always issued by the State Department, okay? Usually, I think it's under Visa Travel. You can always just type in, you can Google Visa Bulletin, and it will bring it up. It comes out once a month. So you can go look at this Visa Bulletin once in a month to determine if priority dates are current, okay? Visa Bulletins don't tell you what priority dates are, and the Visa Bulletin isn't going to tell you what your priority date for your particular client's visa is. The visa bulletin is only going to tell you if that date is current. Remember, I gave you the date January 1st, 2015. Where do we find the priority date? We have to look at the actual visa petition receipt, okay, to determine the priority date. So you look at the receipt on the visa petition to determine priority date. A lot of times it will tell you the priority date. I know in your book you've got some I-130 receipts. I don't know what page it's on, but it'll tell you that priority date. You can look in there to see the priority date, or look at the actual date that it was filed, and that's going to give you your priority date, okay? All right, so let's go back to our visa bulletin. We are now looking at our visa bulletin right now. The date that I gave you that Joe married Maria is January 1st, 2015. We want to look at the visa bulletin. So what I want you guys looking at is, I want you looking at page 2, where it says Family Sponsored Preferences. First of all, we have to figure out what preference category is Maria in, or if she's in a preference category at all. And 2, once we figured that out, is there a visa available for her today? So let's see if we can figure out how you do that, okay? So if you go to this visa bulletin, okay, first thing we're going to figure out is what's the preference category. Joe is a lawful permanent resident of the United States. Maria is not. Joe marries Maria. Okay, so we know a spouse of a permanent resident is actually an F2A, okay? So how do we know what box to look at when we're looking at F2A? We've got 5 columns there. All chargeability, China, India, Mexico, Philippines. We look at the country of birth of Maria to figure out where she's from. Now, I told you Maria's from China, so that means we're going to look at China. And if you look at the box on China, on the chart that I'm showing you, it says 1st October 2013. So what that date means is, that means anyone who filed a visa petition on October 1st, 2013 or before, a visa number is available to them. If that person filed the visa petition on October 2nd, 2013 or after, a visa bulletin would not be available to them. Now, you guys recall, I told you that Joe filed his visa petition on January 1st, 2015. So we see that January 1st, 2015 comes after October 1st, 2013. Therefore, a visa is not available for Maria to come to the United States now. So when will a visa be available for Maria? That's a good question. It's really just kind of a guess. Basically what we have to do is we got to keep checking this visa bulletin every month, and we have to wait until we see the 1st of January 2015 shows up in the box under China. Then Maria can come to the United States. Okay, so what we're going to see is, with the exception of immediate relative, all other family relationships here, you see, have wait times of when they can come to the United States. Okay, so let's pick a second one. Let's say Joe's a U.S. citizen, and Joe has decided to marry Sally, and Sally is from Ecuador. And Joe is a U.S. citizen. Would we find, what category is this, and would we find it on the visa bulletin? We would not find it on the visa bulletin. Joe's a U.S. citizen. He's married a foreigner. Spouses of U.S. citizens, remember, are in that definition of immediate relative. And if you looked under the family-sponsored preferences, F1, F2, F3, and 4, there is no category for a spouse of a U.S. citizen. Why is that? Because there's no quotas, and a visa is always available. So, if Joe marries Sally from Ecuador, can Sally come to the United States right away? Absolutely. A visa is always available to her. So Sally will be able to come to the United States. Okay, so you guys understand that. Immediate relatives, visas are always available. Immediate relatives are not going to be found on the visa petition. Okay? All right, but let's do another one so you guys can understand this. Let's say that Joe now wants to petition for his married son from Ecuador. First of all, what preference category would we be in? We first wanted to determine the preference category. So if we look at the definitions of F3, we see married sons of U.S. citizens. Joe's son is from Ecuador. He is married. So we know that Joe's son his name is, I don't know, Mario. We know that Mario is in preference F3. So then we would go to our chart. We go down to F3. First, and we have to determine what is the date on the actual, the date of filing of the visa petition. Let's say Joe filed this visa petition August 1st, 2000. August 1st, 2000, Joe filed a visa petition for his son Mario from Ecuador. So first of all, Ecuador is not listed, so it would be in the country of all chargeability. So we'd go to F3, because we know F3 is married sons of U.S. citizens. We go over to the little box. It says February 22nd, 2004. February 22nd, 2004 comes after our priority date. Our priority date is, or actually I should say our priority date, which is, I think I said 2000. 2000 comes before 2004. Therefore, we know a visa is available. So now, I'm hoping you guys have noticed, you see the huge waiting times for some of these categories to bring someone over here legally. Look over there at the Philippines. If you had a sister that you wanted to bring over from the Philippines, right now you could only bring over someone if you had filed in 91, okay? Over 20 years, you will see that. So some of these categories have very long waiting periods that individuals have to wait before a visa is available and before they would be able to bring that individual over to the U.S., okay? All right, so just to review, when we're looking at family relationships, and we're talking about immigrant visas now, guys, immigrant visas. Immigrant visas are permanent visas. We're not talking about the temporary visas anymore. We're talking about switching someone that actually wants an immigrant visa to the U.S., that actually plans on coming here to live as a lawful permanent resident and probably eventually becoming a citizen. And so we're starting with the family category. And so what we know about the family category, first of all, immediate relative. We must know that definition. If you guys don't know that definition, make sure that you actually learn the definition of an immediate relative. You go back up here, you see immediate relatives are either spouses of USC or unmarried children under 21 of USC and parents of USC. That's very, very important because their immediate relatives are not on the visa bulletin. There's no quotas, meaning you can file for a USC or child or parents right away. So what we'll see, and you're going to see this on your assignment that you're going to start working on next week, on a marriage case, if someone's filing a marriage case and the USC has married a spouse, since a visa is automatically available, they could file what's called an I-130 and an I-485 together at the same time. It's the only time that you can do that is for an immediate relative or if the visa is available. But when you go and you look at the visa category there, you look at the visa bulletin, none of the categories in the family preference categories are available. So since none of them are available, that means you have to file your I-130 first. You got to get your I-130 approved, and then you got to file your I-485. Okay. All right. So we know what immediate relative is. We know that to look at any of the preference categories, we go to travel.state.gov to print out the visa bulletin. We look at our visa bulletin. The visa bulletin will tell you what the categories are, and then the visa bulletin will tell you actually what whether a priority date is current. Okay? It doesn't tell you what the priority date is. What do you have to do to find the priority date? You got to look at the actual visa petition, the receipt for the visa petition you filed, which is called the I-130. The visa bulletin is only going to tell you whether that receipt number that you're looking at, is it current? Okay? So where do you go to find out? I keep repeating myself, I know, but this is important. Where do you go to find out if a visa, if a priority date is current? Visa bulletin. I'll say it one time. Where do you go to look to see if a priority date is current? Visa bulletin. Okay, so we got that. All right. Where do we go to find out if we don't know the definition of a preference category, if we don't know who is covered by first preference? Visa bulletin. Visa bulletin will give us the definitions also. Okay, and so when we have our receipt for our I-130, because you're going to, immigration practitioners file these, or maybe a client comes and says, hey, my uncle filed, or my sister filed this visa petition for me 15 years ago. Can I adjust status? You're going to get the copy of the receipt. You're going to look at the date. You're going to go to the actual visa bulletin, and you're going to look in these little boxes. Okay? And you guys are going to do an assignment on this actual visa bulletin. And basically, the first thing you're going to do when you get the facts, you want to look to see, are they in a preference category or are they immediate relative? If they're immediate relative, then no waiting period as far as the quota system goes for them to file for their adjustment of status. If they're in a preference category, then there is probably a waiting period, and you need to look and see, is the visa number, the visa date of filing, the priority date, is the priority date current, or do they still need to wait? If the priority date is not current, and they go ahead and they file that I-485 to try to adjust status because they have the I-130 receipt, and then they file the I-45 without that visa number being current, it's going to get denied because it's not available to them. Okay? All right. All right, so what form is filed on behalf of the alien relative? You guys should know this because I've mentioned it quite a few times. I-130. If you're in the U.S., you file it with USCIS. If you're not in the U.S., you would still file it with USCIS. I-130s are always filed with USCIS. And then whether you go through consulate processing would be if you're out of the country, at the consulate in your country, or if you're here in the U.S., then you go to a USCIS office. If you're in the U.S., the alien in the U.S., you can file that I-130 and the I-45 together at the same time. Okay? And it says if alien U.S. to file the I-130 and the I-45 at the same time, you have to be either immediate relative or, again, that priority date has to be current. Okay? All right, so finally, what documents would you attach? Let's say it's a marriage case. Let's just pretend, you know, we got a marriage case here. What would you actually attach to your I-130 to be able to show that you're eligible for a actual immigrant visa? Well, first of all, you got to show the birth certificate of the petitioner, show that the petitioner is a U.S. citizen or that they're, you know, where they were born. If they were, if they're a naturalized citizen, they have to show their naturalization certificate. If you're born in the U.S., they want your U.S. certificate. They do not want your passport. Of course, you got to show the birth of the beneficiary because you got to show what country they're from because that's going to make a difference on priority dates. If you're in the U.S., you got to say proof of your U.S. status. We usually want that as well. Now, interesting thing here. Remember we talked about when we were talking about non-immigrant visas, how important it is to stay out of status, and that if you fall out of status, you can't change to any other type status. We have one exception in immigration law where you can fall out of status and you can still adjust your status, and that is if you marry a U.S. citizen. Marrying a U.S. citizen or being a child where, let's say, a parent marries, a U.S. citizen parent marries an alien and that alien has children, those children and the spouse, it's the only time you can you can be not in status, so to say, where you've fallen out of status. Marrying a U.S. citizen cures that sin. Any other time, if you're married to a lawful permanent resident or any other type category, if you're out of status, you cannot adjust your status to a permanent resident if you've fallen out of status. And fallen out of status means you've let that I-94 expire, your authorization period has expired. Okay? All right, so what other documents would you need? Of course, you need your marriage license, need your divorce decrees, and then we have this thing down here called an I-864 affidavit of support. That's kind of an interesting thing. What actually is the I-864 affidavit of support? It basically, all USCs or permanent residents have to file it. You want to make sure the alien that you're filing for is not going to be subject to the poverty guidelines. So you want to make sure they're not going to become a public charge of the state. And so you have to show that you are making at least 125% above the poverty level when you sponsor someone to bring them over here. If that person that you sponsor actually derives any benefits, any welfare benefits, then the government can actually come back against the petitioner to collect that money, because basically you're saying that, hey, I have enough money, they're not going to become a ward of the state. they're not going to seek any type of welfare benefits. So that's the whole reason they make you file an affidavit of support. Okay? All right. So the purpose, here we go, purpose of the affidavit of support is to actually show intending immigrant has adequate financial support and that the alien won't become a public charge. So they're not going to let you adjust status here if you show you have zero money and that your spouse has zero money. If you're a U.S. citizen and you have zero income, zero money, you're living on welfare, they're not going to let you marry an alien and bring that alien over here that has no job and can't support themselves either, because they don't want you to actually availing yourself to any of the welfare benefits. Okay. So what's the nice thing about becoming an LPR? It's good for 10 years. It's kind of like a driver's license. You can get it renewed after 10 years. They pretty much will actually renew it. The only time they don't usually renew an LPR card is if you have any type of, during that 10-year period, you have any type of criminal convictions that would prevent you from getting a renewal of your permanent resident card. Now, you also see here we have what's called a conditional resident. And this is something that we have that only applies to marriage cases. This is under the Marriage Fraud Act, that if a U.S. citizen marries an alien, okay, and at the time of the interview, they're married less than 2 years at the time of their adjustment interview, not at the time that they file the case, but at the time the actual interview comes up, then they get what's called conditional residency, okay? They're not considered a permanent resident, they're considered a conditional resident. And so they get a conditional residency for 2 years. And at the end of that 2 year, before the end of that 2 year period, they have to file a form that's called an I-751. It's called removal of conditions prior to the expiration of their conditional status. What this means is, and basically the reason this was done, it's to prevent marriage fraud. I mean, in the old days, you used to be able to get married on day 1, file your papers on day 2, maybe have an interview on day 10 of your marriage, be granted a permanent resident card, and on day 11 get divorced. So they didn't want these fraud cases. So what immigration came up with is, under the Marriage Fraud Act, is the conditional resident requirement that if you're married for less than 2 years at the time of your adjustment interview, you get a conditional residency, and that conditional residency for 2 years, so they figured a 2-year period is enough time to see that the couple is actually going to be together. And what they're looking for is proof of cohabitation and proof of financial responsibility. Do you have a lease agreement together? Do you share financial responsibility? Do you have a joint bank account? Are you buying anything together? Have you bought a car together? Things like that. Have you set up a savings account? What are you doing to show that you are actually having financial responsibility together and cohabitation? Okay? And then what happens is when you file for that removal of conditions, you attach all your evidence showing that you've accumulated all these things, bank statements, lease agreements, those kind of things, and then you ask for your removal. Now, I do know you're going to see this on a quiz. I also think it's in your self-test, but I'm going to throw it out there to you. We can get non-immigrants, because we're talking about family immigration, we can get non-immigrants for fiancé. So what is a fiancé non-immigrant? Visa would be a K-1. Actually, I think part of the K-1, you do have a, I'll have you look it up, you have a time frame of once you come into the U.S. that you have to get married. I'll go ahead and tell you what it is, 90 days. So if you got a fiancé visa, you could get a fiancé visa at the consulate, you come into the U.S., you've got 90 days to actually get married and file for your adjustment of status. If you don't get married to that citizen within the 90 days, then what happens is you will not be able to adjust your status or change your status to anything else. Just so you know, you can't like, hey, I'm going to marry you once I get to the U.S., forget it, blow it off. You won't be able to change anything else. You would have to go home. Okay? All right, so that's pretty much it for what we've got tonight, guys. The main thing is you are going to do an assignment on the visa bulletin. So I think I said May, but I'm going to send in your announcement. You're going to use the June visa bulletin. So you use the June visa bulletin for the assignment for this week. hang on to that June visa bulletin because you're going to use it next week as well. So we're going to use the visa bulletin this week for the family preferences. We're going to use the visa bulletin next week for employment when we get into the employment stuff, okay? All right, so that's pretty much all I've got for tonight. Good luck. Email me if you have any questions, and I will see you after the 4th of July. All right, take care. Bye-bye.